Hello and welcome to Verdictum. I'm Sheetal June, and in today's segment we will talk about the Delhi High Court's significant ruling setting legal precedent in posthumous reproduction. The Delhi High Court has allowed an elderly couple to access their deceased son's frozen sperm for surrogacy, setting a significant legal precedent in posthumous reproduction. The court ruled that the Indian law does not prohibit posthumous reproduction provided consent is there. The couple's son passed away in September 2020 from cancer after cryopreserving his sperm due to concerns that his cancer treatment might affect fertility. His parents approached the High Court after the hospital refused to release the sperm, citing unclear legal guidelines. The couple sought to have its grandchild through surrogacy, expressing their desire to continue their son's legacy. The court recognized the sperm sample as part of the individual's biological material, making it inheritable under the Hindu Succession Act in the absence of a spouse or children. Justice Pratibha Singh in her order noted that there was no legal prohibition on posthumous reproduction and ruled that the parents were entitled to the sperm sample. The court also referenced international cases including a 2002 Israeli ruling which allowed parents to use their deceased son's sperm for surrogacy. The couple's 2-month daughter pledged to take full responsibility for the child after the parents' demise, ensuring the continuity of the family line. The ruling touches on the limitations of current Indian laws regarding assisted reproduction. The Assisted Reproductive Technology (ART) Act of 2021 and the Assisted Reproductive Technology Rules of 2022 regulate fertility treatments and posthumous sperm retrieval. However, these laws only apply when a spouse seeks access to a deceased partner's sperms, leaving parents outside the scope of the legislation. In this case, the court found that the ART Act did not cover the circumstances because the legislation had not come into effect at the time of the son's death. This gap in the law enabled the court to authorize the release of the sample to the parents, opening the door to posthumous grandparenthood, a concept not previously addressed in the Indian jurisprudence. A key argument in the case was the classification of sperm as property. The petitioners argued that their son's sperm was part of his biological material, just like any other organ or the human body itself, and thus could be passed on to the legal heirs after death. Under the Hindu Succession Act, parents are classified as Class 1 legal heirs in the absence of a spouse or children, which meant they had legal right to their son's genetic material. The court accepted this argument, treating the preserved sperm as property that could be inherited by the deceased man's parents. This sets an important legal precedent for future cases involving the posthumous retrieval of genetic material. The court's decision establishes a new legal standard for the retrieval of genetic material by individuals other than a spouse, particularly in cases where there are no specific law governing such scenarios. The court made it clear that while the ruling applied to this particular case, it did not set a blanket rule for future instances. The court also emphasized the importance of informed consent and the welfare of the future child, stressing that each case should be evaluated on its own merits. Thank you for watching the video. Hope it was helpful. For more such informative content, subscribe to our channel and download the Verdictum app on iOS and Android devices.